Good morning, good afternoon, good evening, dear colleagues, dear friends. I'm joining you from Geneva, Switzerland, and I'm very pleased to welcome you to this session of the 11th Annual Refugee Law Initiative Seminar Series, which is this year organized in partnership with the Platform on Disaster Displacement. The session of today is on legal responses to cross-border environmental mobility. My name is Atle Solberg, I'm head of the Secretariat of the Platform on Disaster Displacement, PDD. I'm very honored to have been asked to moderate this session on behalf of the Refugee Law Initiative and the PDD. Needless to say, I also wanted to let you know how excited we are at the PDD Secretariat and at PDD to work with Professor David Cantor, Director of the Refugee Law Initiative and Internal Displacement Research Program in this seminar series. We will hear from Professor Cantor a bit later in the session. I want to remind all participants that the seminar is being recorded. So by remaining in the meeting, you are consenting to this being audio and video recorded. Before we start, I would like to take a minute to quickly remind us all of the key concept underpinning this year's seminar series on human mobility, natural hazards, and policy responses. Environmental processes, including those linked to disasters and adverse effect of climate change, shape human mobility, such as displacement, migration, and planned relocation, both within countries as well as across borders. These processes can also entrench immobility for certain groups. Natural hazards that shape mobility in such context encompass the slow onset impacts of climate change and environmental degradation, as well as sudden onset disasters linked to storms, earthquakes, volcanic eruptions, and even biological hazards like the COVID-19 pandemics. It is in this context, and in short, that the sixth webinar session we have organized will look at the question of how can law and policy engage with the impact of natural hazards on human mobility. As some of you may recall, the two initial sessions explored firstly the concept that we use to frame or understand human mobility in the context of disasters and adverse effect of climate change. And secondly, some of the empirical issues and the state of the art regarding knowledge and evidence of such mobility. In session 3, the seminar shifted to consider contemporary legal and policy responses and frameworks to human mobility in disaster and climate change context. For example, in the third session, we had a conversation and reflection on the current global policy debates. We heard about, for example, the two global compacts for migration and on refugees, and we heard some of the opportunities in this mobility framework to address such human mobility. In session 4, we talked about internal displacement in disaster and climate change context, and we also learned a little about how the current high-level panel on internal displacement may pick up on some of the issues that the panelists covered. Today, I'm very honored to moderate the fifth session where we assess legal and policy responses to cross-border movements. And our speakers today will start off by presenting on how the legal response can be to environmental cross-border immobility at global, regional, and national levels, including refugee and human rights law and migration law. Before I will introduce our panels and our speaker, I would like to bring to your attention that we have a chat function in this Zoom meeting. And I invite everyone, as the speakers go ahead and start talking, that you can put questions in the chat box that you would like to make to these speakers. And we will monitor the chat box and also bring that to the attention of the speakers. Without much further ado, I'm very glad, and I want to also let everyone know that we have two speakers from the Pacific joining us. And I think we all can imagine that the time in the Pacific, both in Australia and New Zealand at this time. So we are extremely grateful that we have two speakers that have been awake long until midnight and join us for this session. So first, Speakers today that will look a little into international law frameworks is Professor Jane McAdam at the Kaldor Centre for International Refugee Law at the University of New South Wales. Jane, I'm very happy to give you the floor.
Thank you very much, Atle, and hello everybody. I'd like to begin by acknowledging the traditional owners of the land on which I am here in Sydney and pay my respects to their elders past, present and emerging. Well, I've been invited to speak to you today about how current international law addresses cross-border mobility in the context of climate change and disasters. Well, the short answer is that it doesn't, well, at least not expressly. Neither international refugee law, human rights law, nor the law on statelessness were developed with this predicament in mind. But they do contain principles that affect what states can and can't do when they're faced with people whose lives or well-being are at risk from the adverse impacts of disasters or climate change. And these principles should continue to evolve in light of changing circumstances. So I'd like to take you on a quick tour of these areas of international law to see to what extent they might offer protection to people displaced in the context of climate change and disasters. Of course, it's important to acknowledge at the outset that most disaster displacement will occur within countries. But some people will be displaced across borders, and that's why refugee law is often the entry point in this discussion. It's not necessarily a great entry point though, because such people generally won't qualify for protection as refugees. This is because it's difficult to show that the impacts of disasters or climate change on their own amount to persecution, and that they're occasioned for reasons of one's race, religion, nationality, political opinion, or membership of a particular social group. But that said, refugee law shouldn't automatically be dismissed either. Although there's no such thing legally as a climate refugee, there is such a thing as a refugee whose circumstances are made worse because of climate change. Conflict, persecution, and disasters are often interlinked, and the impacts of disasters may reinforce claims for refugee status, for instance, by exacerbating discrimination or resulting in a breakdown of law and order. In October last year, UNHCR set out some of the legal considerations regarding protection claims associated with disasters or climate change. The document emphasised the importance of understanding climate change impacts in a broad social and political context, and their capacity to adversely affect government and societal structures. As Matthew Scott has argued in his work, it's essential that we appreciate the deeply social nature of disasters, within which existing patterns of discrimination and marginalisation are exacerbated. UNHCR also noted that an evolutionary approach to interpretation means that people displaced by the adverse effects of climate change and disasters can be refugees under regional refugee criteria in the OAU Convention and the Cartagena Declaration, because impacts could constitute events seriously disturbing public order. Under human rights law, the principle of non-refoulement relevantly protects people from forcible return to life-threatening circumstances or other cruel, inhuman, or degrading treatment. However, in the cases that have been brought so far on this basis, decision makers have found that the risk of harm is not yet sufficiently severe to warrant protection. In late 2019, the UN Human Rights Committee considered the situation of a man from Kiribati, who said that if he were deported by New Zealand, his life in Kiribati would be at risk because of climate impacts. The Human Rights Committee found that there was not yet enough evidence to show that he would face life-threatening environmental conditions, or that the government of Kiribati had failed to take programmatic steps to provide for the basic necessities of life in order to meet its positive obligation to fulfil the gentleman's right to life. But the committee did say, and I quote, that the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realised, meaning that protection should be forthcoming before a situation becomes imminently life-threatening. As a matter of legal principle then, the committee accepted that climate change may expose people to risks that trigger the non-refoulement obligations of sending states. While the committee's decision itself is not legally binding, the international legal obligations on which it is based certainly are. There's also a long line of UK and European jurisprudence recognising that destitution or dire humanitarian conditions may constitute inhuman or degrading treatment. But protection so far has only been forthcoming when exposure could be attributed to a state's direct actions or omissions rather than to a general state of affairs. There have been recent media reports of a case in which the Bordeaux Administrative Court of Appeal ruled that a Bangladeshi man could not be deported because he would face a worsening of his respiratory pathology due to air pollution. Although heralded as a landmark judgment on environmental displacement, the decision seems to have been based on principles first established in the European Court of Human Rights case D and the United Kingdom concerning lack of medical treatment. Of course, human rights law is not just remedial, and states have positive duties to respect, protect, and fulfill human rights to safeguard people from foreseeable harm. In certain circumstances, the duty to protect the right to life may require states to evacuate or even to relocate people. Both of these are considered measures of last resort, and permanent relocation in particular is a complex and fraught process that requires in-depth consultation and planning so as to avoid greater vulnerability. Since the territorial integrity of some low-lying small island states is at risk from sea level rise, it's often asked whether their citizens might be rendered stateless. The short answer is probably not. First of all, the protection afforded by the treaties on statelessness is deliberately restricted to people who are not considered as nationals by any state. So unless a small island state were to deprive its citizens of nationality, which would be unlawful in this context, the statelessness definition would only be triggered if there were no longer a state in existence capable of recognising them. Now, this is a highly speculative and convoluted legal argument, and in reality is also unlikely to offer much protection. This is because long before territory is inundated, people will need to move as freshwater supplies decline, temperatures become intolerable, and some areas of land become uninhabitable. It could be many decades or more before the territory itself disappears, by which time many former inhabitants and their descendants might be citizens of other countries. As such, the timeframes between leaving one's country and needing protection elsewhere are mismatched. And from a purely practical perspective, the statelessness treaties aren't well ratified, and few states have a procedure in place to determine who is stateless and thus to provide an appropriate legal status. Thanks in large parts to the efforts of the Nansen Initiative and the Platform on Disaster Displacement in recent years, important language on disasters, climate change, and mobility is now reflected in a range of international instruments, including the Sendai Framework on Disaster Risk Reduction, the Agenda for Sustainable Development, the 2015 Paris Outcome on Climate Change, and the 2018 Global Compacts on refugees and on safe, orderly, and regular migration. A task force on displacement was also established under the auspices of the UNFCCC Warsaw International Mechanism for Loss and Damage associated with climate change impacts in order to develop recommendations for integrated approaches to avert, minimise and address displacement related to the adverse impacts of climate change. So in conclusion, while there are legal gaps in the protection of people displaced in the context of climate change and disasters, there's not a complete void. There are also many effective practices that states could implement right now to address mobility in this context. While time doesn't permit me to expand further, I'm sure that some of these examples will be discussed by our other panelists. Thank you very much for your attention.
Thank you so much, Jane. That was very comprehensive, and it strikes me that in a very short period of time, you have given us ideas on what to work on through refugee law, human rights law, even disaster law and climate change policy framework. So that's extremely useful also for non-legal persons like myself. So thank you so much for always very, very clearly spelling out opportunities as well as limitations. I invite again people to pose questions to Professor McAdam in the chat box. I also would like to remind you that a speaker's bio has been also posted in the chat box. I will not spend much time giving the background from each of the speaker, but you will find more information in the chat box. So again, thank you so much, Jane. Our next speaker, also from the Pacific, probably a bit further east in New Zealand, Professor Richard Bedford from the Waikato University in New Zealand. Richard will speak to us a little about migration and law in the Pacific context. Richard, you have the floor. Thank you so much.
Thank you, Atle. I'm going to try now and load a presentation, which I would like to share with the audience. I'm not sure it is, no, it is not. Unfortunately, it doesn't seem to be coming up from my computer, which is very strange because that usually is what happens. So I won't use the presentation, but I will just talk. What I wanted to emphasize in this 8-minute presentation.
Richard, sorry to interrupt. We can also try to post it from this end if you're interested.
We are there. Yes, thank you. That's very good. I would like to, right. Yep, that's excellent. Thank you very much. And I will, can I control the movement of that, or will I have to ask somebody to move the slide?
I think you need to ask somebody. Susie, go ahead, please.
Sorry, yes, ask to move the slide when you're ready.
Okay. If you can move through this to the first slide, and I will speak to this. Well, basically, Jane has set the context that fits this region that I want to just briefly comment on. For the benefit of the people who are listening, just so you are aware, I am a geographer, not a lawyer. So I'm going to talk a little bit more about the region and the issues of migration and law in the region. And a lot of my thinking is profoundly influenced by the writings of Pacific people, the people who live in the region. In this presentation, there is a little bit of text, and I'm very happy if you want to obtain a copy of the presentation, you can request that from David and his colleagues, and they can send that through. There's a very eminent sociologist, Atle Solberg, he's unfortunately no longer alive, a Tongan, who in a series of essays, if we can go to the next slide, thank you, next slide, yeah, We Are the Ocean. He actually redefines how the peoples of this region see themselves and see their island homes. And when you come to consider migration in the region, it's really important to understand how Pacific people see migration as a process and understand that migration in the context of their island homes. I want to just note here that there was considerable movement between islands in this region before colonial impacts. And this time-honored practice of inter-island movement has been recognized by virtually all of the 21 Pacific Island countries and territories through mutual visa waiver arrangements for visitors from most of the other island countries. So in their own way, they have tried to leave open at least one avenue for the traditional type of movement that they had before. If we can have the next slide. The region, if you took a bird's eye view above the center of the Pacific over the country that Jane mentioned, Kiribati, and I'm going to come back to that in a second, to Tarawa Atoll, this is the world you would see. It's a world of ocean. And this is hardly surprising why sea level rise has become a really critical issue in this region. There isn't a big population in the region. The whole region, the 21 countries have around 12 million people, and 9 million of those people live in one country, Papua New Guinea. So the other 20 share the other 3 million. So we're not talking large numbers of people across this region. And if we just touch on Kiribati, because as Jane said, there was a very important case in New Zealand relating to testing whether somebody could be a climate refugee. This is a country of only 116,000 people, and over half of them live in the urban area. If you can go to the next slide, please. And if you've never seen a coral atoll, this is the environment in South Tarawa. This is the South Tarawa urban area. It is a strip of coral about 20 kilometers long, and 60-odd thousand people are living in this environment. And it was in this environment that the case that Jane referred to related. The person in New Zealand had someone who had overstayed a visa and had appealed to become a refugee. That had been denied. He was about to be deported. He appealed again, and the case went to New Zealand's highest court, the Supreme Court. But as Jane's explained, this environment into which the case related is still habitable, but there's no question that this environment is under significant threat. So this is one context for migration and law in the region. But I want to move on to a couple of others. So if we can go to the next slide. The critical thing about the region is, except for one country, there are no land boundaries. Boundaries between countries are, in many cases, to the people who live in the region, fictive entities. They are lines on a map. They are not in any way, you don't see them as you travel across the region. And in most of the countries, they had actually very little relevance to the movements of indigenous peoples until after the Second World War. One of the things about migration law in this part of the world is that it's generally associated with constraining rather than providing opportunities for movement. As I've already noted, Pacific countries welcome short-term visitors through their visa waiver policies, but they've all fallen into the sort of European practice of having restrictive policies relating to migration for work and for residence. If we can go to the next slide. But in this region, migration is very much an adaptation strategy and has been all through the colonial era and the years since independence from about the 1970s. Permanent movement as well as temporary movement have been strategies that Pacific people have used to try and minimize risk, especially in countries with limited land resources or prone to destructive environmental hazards. To come back to Kiribati, in the 1950s and 60s, when there was a perception that population growth was going to outstrip land on these small atolls, there was movement of people from the southern atolls into other atolls that were uninhabited in the region, in the country, and then subsequently the relocation of those people to a different colony with a different environment. So relocation of people because of environmental constraints is not unknown in the history of this region. There's also been extensive labor migration, people moving to work in different parts of the region and outside the region. If we go to the next slide. The issues today, though, are that because of the way migration law and migration policies operate in the countries within the region, as well as on the border, like Australia, New Zealand, Canada, United States, the movement tends to be and has to be temporary. There are very restrictive policies restricting permanent migration. So because of this, as climate change unfolds in the region, the focus increasingly is on building more resilient livelihoods in the islands, rather than looking at relocating somewhere else and living in a different country. And this has had an impact on the way people in the region themselves now view climate change. So if we go to the next slide, the COVID-19 pandemic, which abruptly closed all the borders and trapped in every one of these countries, trapped some temporary migrants, people who were visitors, who were labor migrants, who were business people. They have not been able to return. And what it's required is some policy responses to address the vulnerable positions of temporary migrants. And the question now arises, can some of these policy responses be used to assist migrants in the longer term as we deal with climate change? Can they become part of migration law? And I'm now going to finish with just 2 slides to show some regional responses. The next slide, please. Something which our chair and his organization, the platform Disaster Displacement, Displacement Disaster, is involved in, and several other agencies working with policymakers in the region, is a dialogue to support responses to climate change related migration and displacement and relocation. The challenge now, though, is, if we go to the last slide, is that our region has had a history since the 1970s of the independent and self-governing states working collectively to try and address major economic and political challenges. But this week, all of the small island countries of the Northern and Central Pacific, including Kiribati, have decided to withdraw from this regional arrangement, the Pacific Islands Forum. And this is a group that PDD and the other international agencies I've just been referring to are currently working with to try and develop initiatives to address legal issues relating to migration linked with disasters. So in a sense, a disaster has hit the region, a completely unexpected one, like COVID, in that the regional forum that addresses these has currently, very recently, been fractured. So there are new challenges facing how we address migration and law in the Pacific. Thank you.
Richard, thank you so much for this presentation and for bringing the Pacific so close to us. And I think it would be good to maybe look a bit more into the implication of what's happening in the Pacific Island Forum. So maybe in the round of discussion, we can come back to some of your reflection on that. It's on the news in the morning here in Europe. So it would be good to maybe go a bit deeper into that. So thank you so much for sharing this with us. So without much further ado, I'm very pleased now to introduce Professor David Cantor from the Refugee Law Initiative, and he will speak specifically around national law and lessons from the America. David, you have the floor.
Great. Well, many thanks, Atle, and hello, everybody. For today's seminar, I'd like to share some research from an article published last month in the Chicago Journal of International Law. It's called Environment, Mobility and International Law, a New Approach in the Americas, and I'll post the link in the chat very shortly. There's been a great deal of interest over the past 15 to 20 years in how law regulates the situation of people who cross a border in the context of disasters linked to natural hazards, especially in light of climate change. Yet, as scholars, it sometimes seems as if we've reached an impasse. There appears to be a great deal of consensus, as Jane outlined so eloquently, that existing law has relatively little to say about this issue except around the margins, and that a gap in international protection exists. However, we mostly seem to propose filling this gap by building on specific bodies of international law, particularly environmental law and refugee law, either by interpreting existing treaty law differently or by creating new treaties. My concern is not just that a lot of the thinking on this topic seems now quite samey, but that in practice, these proposals haven't really gained much traction amongst states who, after all, are the main creators of international law. With that in mind, I'd like to suggest a different method of attacking the problem. What happens if, instead of starting from an abstract international law perspective, we instead take national law practice as our starting point? In sketching out an analysis along these lines, I'll concentrate on just one region, that of the Americas. This reflects the growing wisdom in the research community that a regional rather than a global approach offers a way out of the impasse. By contrast, though, my focus is on the national law of states within one such region, rather than on regional international law. There are three main points that I'd like to make, as set out on the slide. Coming to the first, it's a matter of common knowledge, I think, that the Americas as a region has considerable experience of both slow and sudden impact disasters linked to natural hazards. And indeed, my article shows that these dynamics sometimes result in or contribute to cross-border movement, although this seems to generally be on a relatively modest scale. Yet, in the Americas, this is a challenge. This is not a new challenge for states, but rather one that's been recognised for decades. Not only that, but as a matter of national law practice, most states in the Americas have at least at some point granted legal entry and stay to people affected by such disasters. My first point then is that the absence of international law on this issue does not necessarily mean that there is a wider absence of law. At least in the Americas, many states have long been aware of the issue and use national law provisions to resolve the legal situation of people who cross borders in the context of disasters. On my second point, I'd like to reflect on the tendency to characterise cross-border mobility in this context as primarily an issue of international protection. Here, my analysis of national practice in the Americas shows that states treat such movement as a matter of international protection in only really very limited scenarios, usually where the disaster unleashes persecution or violence due to the breakdown of law and order. Rather, the issue of cross-border movement in the disaster context is seen by states principally as a matter to be resolved by the application of immigration law. This makes a lot of sense in the Americas. Indeed, the reality in this region seems to be that people who cross borders in the context of disasters, even slow onset ones, tend to go to countries where they already have links. And as a basis for legal entry and stay, they avail themselves of ordinary migration categories based on links such as family, work, and studies. The disaster element of their movement may seem legally invisible in all this, but in practice, such ordinary migration categories in national law, including those based on sub-regional free movement arrangements, do offer a main route of escape from the impact of a disaster. As such, alongside ideas about creating bold new treaties for climate or environmental refugees and so on, the pragmatic need to ensure that destination countries do not unduly restrict ordinary migration pathways following a disaster is equally important. On this note, it's significant that as a matter of law and practice, a number of states in the Americas actually go in the opposite direction and deliberately use these ordinary migration categories in national law in a positive manner, applying them in a flexible or expedited way to facilitate the entry and stay of disaster-affected people with links to the destination state. This shows, at the national level, how ordinary immigration provisions can be a key part of the overall response to cross-border movement in the disaster context. Yet, even for disaster-affected people on the move who lack a link with the destination country, a very wide range of states in the Americas positively apply special or exceptional migration categories within their national immigration law to allow entry or stay to such non-nationals. These exceptional migration categories are exercised in favour of persons affected by a disaster, usually based on national law concepts of humanitarian considerations or broader forms of discretion in immigration law. However, increasingly, the immigration law provisions of states in the Americas have also expressly recognised disasters as a basis for the application of such exceptional migration categories. You can see some examples on the slide, and here on the following slide is a list of some of the countries who've been involved in this practice. Crucially then, for my point 2, the logic in these countries and in the use of these provisions is not usually a logic of forward-looking international protection of rights, but rather the pragmatic criteria that the person is or has been seriously affected by the disaster. With this in mind, my third and final point is that these widespread elements of mainly immigration law practice in the Americas offer a solid basis for building common approaches in distinct sub-regions to this challenge of cross-border mobility in disaster contexts. Examples of frameworks already developed in relevant sub-regional forums in the Americas by governments with the support of the Platform on Disaster Displacement are shown on the slide. Crucially, these frameworks do not require new national or international laws. Instead, they aim to improve the response to cross-border movement in the context of disasters, including disasters linked to climate change, by consolidating a similar approach across the region to the interpretation and application of pertinent immigration provisions that already exist in national law. Recent developments in this region suggest that these frameworks are already having an impact on state practice, as is the case for the bilateral accord between Costa Rica and Panama on how to deal with cross-border displacement in the context of disasters. Finally, for those interested in the implications of this research for the development of international law more generally, it seems that states in this region, at least, have relatively little appetite for our inventive scholarly proposals, our top-down proposals for new treaties on climate or environmental refugees, and little appetite equally for top-down, bold and far-reaching interpretations of existing refugee law. However, perhaps building bottom-up, directly on the considerable degree of political will and consensus and practice that already exists in immigration law at the national level across this region, this may begin to offer a fruitful alternative model. Many thanks.
Thank you so much, David. As always, very clear. I cannot not mention, the tremendous work you have done and how the Nansen Initiative and also the Platform on Disaster Displacement have been informed and advised by your research and work. You have really opened up some of the conceptual thinking around these issues, and I'm really grateful for that contribution you have made to our work by this very systematic mapping and analysis of those implications. I need to mention that. I'm also always asking my question, maybe I can leave that with you. You speak about Americas and how does this travel to other regions? How do you see opportunities to build on this in other regions? And I know that's a difficult question, but I think there are evidently lessons learned in terms of approaches. So maybe I can leave that to you. I also just remind everyone that you have opportunities to post questions. I see there is a question from Florian Heisel to Jane. Maybe Jane, you want to have a look at the question and prepare yourself. And then I will use the we will use the next 9 minutes to introduce the next speaker. And now we move to another region. I'm very pleased to introduce Mrs. Lucy Daxbacher from the Intergovernmental Authority on Development Secretariat in Djibouti. I think you are currently in Djibouti, Lucy, but somebody told me that you are now heading the IGAD Secretariat office in Khartoum, Sudan. But anyway, welcome, and you have the floor. Thank you.
Thank you very much, Atle, and also Professor David and the colleagues. It's a pleasure to be here, and greetings from IGAD. I'm in Djibouti right now. I'm responsible for the protocol on free movement of persons and transhumans in IGAD region, but also recently I got a new appointment as head of mission of IGAD to the Republic of Uganda. So thank you very much once again. I'm just wondering, shall we have the presentation from your side?
Lucy, it's being screened now.
Yeah, okay. Thank you, I see it very well. So I think many of us know probably the region. I'm sure you've worked in this region, probably short term or long term. The Intergovernmental Authority on Development was initially founded in 1986. And that was as a result of drought, desertification. But also, if you recall, in the 80s, we also had desert locusts. So that is the time when IGAD was formed as a response to drought and development. But then again, the authority was raised in 1990s, a regional integration aspect, and the authority comprises the 8 countries of IGAD, Sudan, Somalia, Djibouti, Ethiopia, also the East African countries of Kenya and Uganda, as well as South Sudan when it got its independence. So the authority, this region of IGAD is arid and semi-arid. And this characteristic covers about 70% of the region. And so natural disasters are usually recurrent and common. And the most common is drought, as I mentioned before, also seasonal flooding. And also we have challenges now of locusts. As I mentioned, even in the 80s, we had locusts. And also what is prominent about this region is its fragility in terms of conflict, not just climate-related vulnerability, but conflict, which creates and even increases the vulnerability of citizens of IGAD region to natural disasters. And over the years, the disasters have become more and more frequent. I have some updated statistics and data, but as you know, IGAD has specialized institutes. We have the IGAD Center for Pastoral and Arid Lands Development, ICPALD, which specializes on livestock development in the region. Because as I said, being semi-arid and arid, pastoralism or transhumance is a major economic adaptation mechanism for survival of our citizens. And then also we have a specialized center on climate prediction, which we call ICPAC. So I would interest all of you, when you have time, you can visit the websites of our specialized centers, ICPAC and ICPALD. We have seen of recent floods. We had recent floods in Somalia, which displaced over 270 persons. We also had seasonal flooding in Djibouti. And this also affected thousands of people, also in South Sudan. Now, if we can just move further, Atle, whoever is managing the... So we have a figure of displacement in the IGAD region that we've presented, and you can actually see that over the years, we are getting more advanced in terms of vulnerability to natural disasters, and I've given you some indicators. Then most recently, we have had a swarm of locusts, which affected 1/3 of cropping households and 1/2 of livestock rearing households in the region. And the ICPAC very well elaborates there a map of the region that was affected by the locust invasion. Now in IGAD, we have a very prominent characteristic of a moving population. Populations move from conflict, populations move because of natural disasters. So IGAD is basically a region where migration is really a key feature, and it's mixed migration. And therefore we have the regional migration policy framework. As a regional economic community, we are building block to African Union. You know, we have the continental migration policy framework, but then in IGAD, we specified a regional migration policy framework to address the specificities of the IGAD region. And among them is actually the mixed migration phenomenon. And then we have the Migration Action Plan, 2015-2020. One of the key features of our migration policy was the commitment, follow up on the commitment of IGAD member states to develop and implement a regime of free movement of persons in IGAD region. And this led us to launch a process in which we discussed with member states and developed the protocol on free movement of persons in IGAD region. And in both the preamble and Article 16, we have integrated in this legislative regional framework the Article 16, which specifically addresses the movement of persons affected by disasters. And recently, end of 2020, we did have member states elaborate a roadmap. And on the first phase of the roadmap for the implementation of the protocol, we have action number 8, which specifically addresses the issue of enhancing the capability of member states to address the populations and support them who have been displaced by natural disasters. So this said, the member states specifically recognized the contribution that would come from the protocol towards safeguarding the rights, towards safeguarding the livelihoods, towards safeguarding the giving protection to persons displaced by disasters, as well as the adverse effects of climate change and environmental degradation. And therefore, there are specific commitments that member states have made in Article 16. The specific commitments are that member states will allow citizens of another member state who are moving in anticipation of, during, or in the aftermath of disaster to enter into their territory, as long as they are registered in accordance with the national law. And then also member states have committed themselves to extending the stay of such persons displaced by disasters, and also to ensure the safeguarding of their rights, rights to social services, rights to livelihood opportunities, as long as they still cannot return to their countries of origin or their communities at a reasonable time, or when this is not possible. So member states have committed themselves to this within the substantive Article 16 of the protocol. Now, in the roadmap, we have under phase 1, a commitment by the member states of IGAD to develop, review, and harmonize laws, policies, and procedures to facilitate the movement of persons displaced by disasters in accordance with the protocol Article 16 that I just spoke about. Now, this is the substantive legal framework that now IGAD has, which will now enable the IGAD Secretariat and the member states to actually respond to situations of displacement arising from natural disasters, whether of drought or floods, locusts, and any other natural disasters like desertification. And we believe that the region then requires substantive support, especially technical assistance, specialized technical assistance to the member states, so that we can then strengthen their capabilities to actually implement their commitments to Article 16 of the Protocol on Free Movement of Persons and activity number 8 in the roadmap of the protocol. I thank you very much.
Thank you so much, Lucian. Apologies if there was some problem with the slides, but I think we got through the slides quite well, and again, very clear your message. So thank you so much for joining us today. I also know that you worked very hard in the IGAD Secretariat to support member states in this process. So congratulations for that hard work, and also I'm very excited on what's coming next on the roadmap for implementation. So maybe in the next round you could tell us a little about how do we get to the next stage. That ends the panel. I would like to thank all of them. We have already some questions. So I have noted that Florian Hassel, I think he has a question for you, Jane, about the policy development in the European Union, and whether a Swedish model or another model to be followed. I hope you have seen the questions, and maybe you can help me to reformulate it when you report back, because people that have watched this webinar cannot see the chat box. I'll be happy to read it out also if that's better. I think also for Jerome Ellie from ICWA, there is a question for all speakers on strategic litigations. I invite the speakers to look into that as well. And then finally, John Bingham, a question on the Global Compact for Migration and some of the opportunities. This is directed to Jane and David. I propose we turn maybe back to the order of the speakers and maybe ask Jane to share some of her feedback on these questions. Maybe you have seen something else in the chat box that I haven't seen, but it's over to you, Jane. And then we can go in the order of the speakers to responding some of the traffic on the chat box.
Thank you very much, Atle, and thank you to everybody for your questions. The first one that was directed to me does relate to legislation in Sweden concerning a legal status for persons affected by environmental related displacement. And it was noted that Sweden is an outlier in the EU, with most other member states relying instead on subsidiary protection. Now, I may be out of date, so forgive me if that's the case, but certainly for a time that provision was suspended in Swedish law. I know it was revisited, I think, on an annual basis, and I thought it was still not in effect, but I would love to know if it now is. But yes, I mean, certainly in terms of having provision in domestic law in Europe, that on the basis that protection would be afforded because of disaster or environmentally driven movement, it was quite novel. So, you know, the question is, should other states adopt a similar kind of provision? I mean, of course, I wouldn't say no. The question is whether the political will is there, and I think it simply is not at this stage. The fact that there might not be national provisions so expressly on this point, though, doesn't mean that there's no protection available. And I think that's where there are 2 points to make. One is that in some cases, people will be refugees. And if I could point not only to the UNHCR legal considerations I mentioned and which have been noted in the chat, but also to 2 very extensive papers prepared by Sanjula Weerasinghe for UNHCR on their website, which really drill down to the application of the Refugee Convention and those sort of nexus, the nexus between disasters and conflict and so on. But the second point is that subsidiary protection can also extend to protect people from return to inhuman or degrading treatment. Now in Europe, that's circumscribed in such a way that the threshold will be very, very high. And I would also endorse what David was saying more generally about the use of migration opportunities. Certainly in my own region, that's something I advocate very, very strongly, because we don't have legislative provisions in Australian law to protect people at risk of disaster or climate change related displacement. But with the Pacific, what Pacific Islanders themselves have called for, and what I'm sort of encouraging at the other end, is developing longer term strategies for people to move if they wish to on a more voluntary basis. And New Zealand has a well-developed program, particularly in that regard, the Pacific Access category. I might just quickly turn to the question about strategic litigation, and David, you might have more to say on this, but in addition to the Tesiota case, which was taken to the UN Human Rights Committee, there's another complaint on foot to the UN Special Rapporteurs concerning, it's a claim against the United States, and it concerns the fact that groups haven't been relocated from coastal areas and Alaskan Native communities when they've been requesting this for many, many years. And the argument is that the US is on notice and has been on notice for a long time that their lives and livelihoods are threatened. And they're calling on the special rapporteurs to do a number of things, but particularly recognising the threat that climate change is posing to their traditional homelands. I think strategic litigation has a role to play. It's not necessarily going to be the way out of this, but it's certainly, I mean, the Kiribati case, for example, has drawn global attention to the issue. And I think as Professor Bedford said in his presentation, it really came about because Mr. Tesiota had overstayed his visa in New Zealand, and he had a lawyer who thought, how can we take this, how can we think about his case in a different way, and that's how the claims emerged right through the New Zealand courts straight up to the UN Human Rights Committee. And then there was a question partly addressed to me about the Global Compact for Migration, which is quite groundbreaking in its particular provisions that states have themselves agreed to take action to address migration that is linked to disasters, environmental degradation and climate change. There was a report that the Secretary General commissioned, or did rather, 2 years on from the adoption of the Global Compact, and 54 member states of the UN responded. When it comes to action that's been taken specifically on these provisions, there's not a lot that can be directly attributed. There is discussion in that document about mechanisms that a number of countries had already put into place, but not a lot of what's actually happened. In a different section, there's mention, for example, of a pilot program that Spain has initiated to enable labour migration from Senegal. Whether that would assist some people or not, maybe, but it's not framed in the context of climate change. Perhaps the most progressive states in this respect have been in the Pacific. Fiji has developed its own internal guidelines on relocation, as well as displacement, and Vanuatu likewise has national guidelines on displacement internally. So those Pacific countries are leading the way.
Thank you, Jane, for a very comprehensive response and detail. There is in the chat box an information from Elin Jakobsson on the Aliens Act in Sweden. So maybe if Jane, you can have a quick look at that, and if you want to comment on that in the next round, you are welcome to do that. We said we will follow the order of the speaker. Richard, there is a question about regional approaches. Would you like to take that, or do you have any other comments or aspect to what you have heard? I think you need to unmute, Richard. Richard? Sorry, you need to unmute.
Apologies. Robert Freeman has posted an interesting question about possible limitations to regional approaches to addressing legal aspects of migration in the context of disaster. I think his question is a good one in the sense that it may put the burden increasingly on the states in regions that have got significant issues to address the issues themselves. But on the other hand, one of the things that's made the whole approach to addressing disaster in, say, a country like, in a region like the Pacific problematic is that one area that the states have tended to be very strict about their national rights and provision is their immigration law. And we have looked fairly carefully at immigration law across the different countries in the Pacific. And as I noted in my presentation, states generally have been willing to allow people to visit and spend time. And as David mentioned in the Latin American case, there are diasporas of people from many of the countries in neighboring countries. So there has been a spread of population from different parts of the region into other parts. But when it comes to opportunities to stay in the country and work and longer term to reside, then there's a tendency to be quite strict about rights for this. And one of our hopes in the recent work that we've been doing, and I've been working with the lawyer that Jane referred to, who dealt with the New Zealand refugee case, what we've been trying to do is to do, in fact, what David has been doing in Latin America, is to look at how you can use your existing immigration laws to address a host of these issues, and also looking within the national frameworks for immigration to where there might still be examples of ways in which traditional rights to move between these countries still exist. Because the boundary lines that exist and can't be seen in the ocean between countries, of course, have separated peoples who used to travel across the ocean to work on lands or to marry or to interact. They've, as I said, they're fictive entities in terms of the everyday life of people often, especially when they're neighboring islands. And it's interesting that in a number of countries under the COVID-19 response, these traditional rights of being able to move were allowed. And there have been issues about spread of disease, of course, but in many parts of this region, there has been no COVID-19, and therefore there isn't a major risk of people traveling from one island country to the other. So I think the opportunity in the region is to build on what the sociologist, the Tongan sociologist I referred to at the beginning of my presentation, to build on some of the ideas that he articulates that underpin the ways in which Pacific peoples live and the ways in which they have moved in the past, and to bring these ideas back into a firmer discussion of how the region might operate long term in this context. I don't think it's, to answer the question that Robert's posed, I don't think it allows the neighbouring countries off the hook. And I do know that through what work Jane's been doing in Australia and the work that Bruce Burson has been doing in New Zealand, the lawyer who dealt with the Kiribati case, that there is active engagement with the governments in those countries to try and ensure that as the situation in the Pacific might deteriorate long term, that there are more pathways through the standard immigration law frameworks. There are more pathways for Pacific peoples to move. And the regional approach in the Pacific does involve those countries directly, not just the island countries on their own. I won't comment on the other questions. I think there is opportunity, I think, for David to respond on a couple of the questions.
Thank you, Richard. That was very grounded. Excellent. Thank you so much for that answer. I really enjoyed listening to that. David, I think you have a few questions to look at. I also want to highlight the chat box and also thank UNHCR for sharing some of their tools. The legal consideration has been mentioned. So thank you so much from colleague from UNHCR for posting them and bringing that to our attention. David, you have a few questions that you can answer very cleverly, I'm sure.
You're setting the bar far too high for me there, Atle, but I'll give it a go. Okay, so I'm going to actually start in reverse order with the question about, if you like, the relationship between regional and global. And I think it's a good one. There are several aspects to that question. One of them is, do we risk, what are the limitations in privileging a regional approach? And I think that's a fair question to ask. What I would say in response is that if you look at most kinds of movements, be they migratory movements, refugee movements, what have you, the vast majority of them tend to be intra-regional. Yeah? So most people move within regions rather than outside them. It's not to say movement between regions doesn't happen, but it's certainly less common. Okay, so I think one of the things that's been useful in this seminar series has been the way that the evidence was presented in earlier presentations. And I think if we engage quite carefully with what the data actually is on movement in the context of disasters, including those linked to climate change, then we get a clearer picture of where people are actually moving as a result of those sorts of processes, and therefore really where the need is in terms of tweaking the legal response, as I think Richard and Bruce Burson have suggested in the Pacific. And I must say I found that the article that was written on that really a great inspiration in thinking about Latin America. So yeah, if we look at the reality of the patterns of movement, then a lot of those tend to be intra-regional, and that, it seems to me, would be one good reason to focus on regional approaches. Regions often have similar kinds of problems in terms of the sorts of disasters they encounter and the kind of the patterns of movement, sometimes even in the kind of legal systems that they have. And so I think that there are strong arguments for making a regional approach. Against that, I should say that I wasn't actually arguing for a regional approach. I was arguing for looking at national law in one region, which is a slightly different thing. I mean, Atle's question about regions was, well, why couldn't we build on what's being done at the national level in Latin America and build on that elsewhere? So, potentially a global approach might be envisaged along those sorts of lines. But I suppose, if you consider that as a kind of America's approach, Atle's question gets onto this issue of, how could one build on that in other regions? And I think it's interesting to hear that there is work looking at that in the Pacific, and that will be really exciting to see when that comes out. One thing that maybe you can draw from the Latin America example is that rather than the tendency to look at kind of refugee law, international protection law, actually a lot of what seems to be going on in practice in terms of the way in which law accommodates movement in the context of disasters, including climate change, is under the hat of migration law more broadly. And so that's one learning, I guess, that one can take away from that. Having said that, clearly there may well be different approaches in other regions. Tamara Wood, again through the Nansen Initiative and Platform on Disaster Displacement, published a very interesting study on what was being done at the regional level in
test
Africa.
center for COVID, for Corona. So it's actually.
Sorry. Okay. So I would recommend Tamara Wood's study to anybody who's interested in looking at how things play out in the African context. I think she's looking predominantly at kind of international or interstate action, but again, Lucy Daxbacher could possibly add in something there as well. On going back to the original question about regions, though, there is this question about, doesn't looking at regions let richer states who contribute to climate change off the hook? And there's certainly an argument there about responsibility. Jane, I think, has written quite a bit about that, as have others, looking at the advantages and also, I think, the limitations of those sorts of approaches, morally, pragmatically, etc. But one thing I would say is that not all movement that's related to environment or environmental hazards or disasters is due to climate change. Okay, and it's important to make that clear. There are plenty of disasters where the link to climate change is not that strong. And even for those where one might assert a link to climate change, making the link between the disaster, climate change, and then the movement as a result of that, in many instances can be quite a complex operation. And again, Jane and others have written on that quite extensively. So I think it's important to say that, yeah, of course, this issue of contribution to climate change is a discussion that's worth having. But in the meantime, I think having a broader view about disasters and how they impact on movement needs to also be kind of held in hand at the same time. I think Jane's done a fantastic job of talking about the other questions. I don't have much to add there. But Atle, I wondered if you wanted to say a little bit more about the perspective of PDD around the Global Compact on migration and what's happened as a result of that, or if anything has happened as a result of that, perhaps after Lucy's had a chance to respond to her questions.
Thank you, David. Yes, I might say a few words. Not sure if I can add much. I want to give the floor to Lucy then. And Lucy, there is a question from you from Jerome Ellie from IGAD. I don't know whether you have seen it. And there are also, of course, the question about regional approaches. So over to you, Lucy. I'd be happy to read the question from Jerome if you can see it.
Thank you so much, Atle. I think I'll start with the IGAD support platform that was launched in 2019 as a contribution to the Global Compact on Refugees. I believe that we carried forward that commitment from Geneva, and with the European Union have developed a project that will just carry forward some of the ideas that will be addressed under the under the support platform. Now, for now, the member states just completed the development of the protocol and the roadmap. And that having been the case, it came a little bit later than when the concept of the support platform was designed. However, once now that we have a regional policy framework or a regional piece of legislation in the form of a protocol, I believe the opportunities for us to develop further any other actions that the support platform can actually implement with the member states. Usually, IGAD has a very rigorous IGAD migration governance architecture, which really includes, which kind of gives the member states very key responsibility to make decisions on policy matters, on practical matters regarding migration. And therefore, I believe the support platform is a key tool for us to roll out any other decisions, any other actions that contribute to managing natural disaster displacement or displacement arising from climate change. I think it's a very big opportunity, both that the platform exists and also that it has actually been taken forward by member states and the Secretariat, and also a big opportunity that now we have the protocol, which will then help us be grounded in any policy action or practical matters of programming at member state level. And then regarding the regional approach, I do believe that looking at the experience of IGAD region with regard to a very high number of migrants, refugees, which are covered by the convention, but also other migrants, economic migrants, migrants moving away from natural disasters. I believe that a strong regional approach is still of an advantage. It is still something we really need to continue to working on. We've managed millions of refugees in the region. Uganda, Ethiopia, Kenya has hosted many refugees, but also amidst those refugees, for example, when you examine closely the refugees that come from South Sudan into Uganda, I'm from Uganda. Sometimes we have people coming in as refugees, especially at times when there is no conflict or no war in South Sudan, but they are actually crossing over because they did not plant during the planting season, either because they had flooded gardens or because they just missed the rains, so it's dry during the planting season. So that regional approach is still very important. And then also for me, I look at the opportunity that is highly likely that the people who move can actually go back to their homes when opportunity presents itself, when the conditions for return are appropriate and there is a positive environment, or they can go back. So of course, the international commitments and obligations of well-off countries are always is always very important. And I believe with the compacts on migration and on refugees, the global commitment is good, is visible, and it's actually supporting the regional approaches as well. So in my opinion, I think we need both approaches. We need both approaches. It's just that we need to support our governments, our member states, strengthen their capabilities to actually minimize the movement of citizens across in such vulnerable states, either from natural disasters or from conflict and so on. So I believe that both approaches are good, the regionalization of response and also the international responsibility sharing. Thank you so much.
Thank you, Lucy, for sharing those perspectives, also these examples from the region. I think we are coming towards an end. So what I will propose is that we invite all the speakers in the order that they have spoken to say a few final remarks. You can spend a minute or two, please, and share whatever perspective you feel have been missing or what you want to respond to. Before we do that, just quickly to David's question on the GCM and whether the provision objective 2 and 5 and 21 has energized these policy developments. To be very honest, I think we don't really know yet. It's maybe too early. I think the COVID-19 pandemic has also probably taken a lot of attention from some issues. I'm mentioning it because that is one of the reasons that we will with partner, and I hope many online today will be joining us in that effort. We would like to do a mapping of that. As you all know, in 2022, there is an International Migration Review Forum that will take stock of implementation. So in support of that review forum in 2022, we as PDD would like to do a mapping essentially, and then maybe John, we will be better able to respond to that question in a more systematic manner. I do think there are examples where you have more energy and it's been concretized, and maybe we can work with you on that to do that mapping. So look forward to that. Turning then to the closing session of the seminar. I see there are some exchange from Jane and then some feedback from you, John. No further questions. Then I think we just invite the speakers to provide a few final remarks. So Jane, would you like to go first?
Thank you very much, Atle, and thank you again for having me as part of this webinar. I'd also like to thank Ellen for providing that update on the Swedish law. And I've just noted in the chat too, a project that Matthew Scott has examining some of the protection applications that have been lodged in Sweden, both under that, well, if any, under that provision, but also more broadly. I just thought in this context, it might be worth also mentioning for those who aren't aware that in one of the executive orders that President Biden issued, this one just last week, he's ordered a report into climate change and its impact on migration, including forced migration, internal displacement and planned relocation, and wants the report to examine, among other things, options for protection and resettlement for people displaced, as it's worded, directly or indirectly from climate change, which is interesting concept. But I mean, it's interesting that this has been commissioned. It's something that Obama certainly looked at in the context of the relocation of communities, although that didn't really go anywhere. And it comes off the back too of two bills that were proposed in the House and the Senate in the US in 2019 to authorise, among other things, the admission of climate displaced persons, as it was put. So I think, you know, sometimes politically it's quite clear these initiatives won't go anywhere. At other times, I mean, certainly with the executive order at the moment, who knows where that report might lead. But I think this, along with strategic litigation, along with the academic thinking, the policy work, the on the ground evidence gathering and knowledge building that so many of you are doing, all of it is vital, because I'm paraphrasing now what David said, but I think international law can be looked at two ways around. And if nothing else, the practices we're seeing are building up that body of state practice that over time may come to mean something more for international law purposes.
Thank you, Jane, and thank you for mentioning that executive order. I think we all have watched that development the last couple of days, and maybe this community could also share approaches on how to respond to that call for a report. So thank you for mentioning that. Richard.
Thank you for the opportunity to be part of the webinar. I've found it extremely interesting. And I was particularly interested in some of the things that Lucy said, as well as David, about different regions. I do think there is a lot of merit in having a regional focus to some of the discussions around responses to legal responses to environmental migration. And I think one of the reasons for this too is that we need to be very prepared to appreciate that people in different parts of the world can have very different ways of viewing the places that they live in and their attachments to those places. I think a lot of the debate about migration and environmental displacement assumes that people will not find it difficult to adjust to and live in another place if they have to move from the one that they're in. But one of the enduring messages that comes from all of the island countries in the Pacific is that our places are us. They are us as people. They are not inanimate objects that we can just sort of walk away from and be in another place and be comfortable. And I think it's very important to be aware of the ways in which people view their environments and see their place within it when we talk about migration connected with environment. The ties to land are incredibly strong in the Pacific. And some of you in the audience who are participating will be aware that Kiribati had a president a few years ago who had a very, very far-reaching way of thinking about his country and about the future for his people. He had a near-term view, which was we want to continue developing our country so that it's the best place our people could live in. But in the long term, we may have to leave it, and we need to think about that. The current government of Kiribati doesn't want to have a discourse about having to leave the country. It actually wants the rest of the world to come to grips with the fact that if there are changes made on an international scale, they may not have to leave their country. And once you start talking about having to leave your country in the long term, you build in a self-fulfilling prophecy that in the long run, a situation will take over where nobody can do anything about it and everybody will have to leave. So a challenge that's coming from the Pacific to the rest of the world is do something to mitigate the effects of climate change. Don't just plan for our long-term relocation. We do not want to leave our places. Thank you.
Thank you, Richard, for that message. I think that's also what we hear quite clearly when we work with governments and others in the Pacific. So thanks a lot for that. David, a few final remarks from your side?
Yes, just one very narrow historical point and one broader contemporary point. The historical point is talking about Biden's executive order. Until 1980, when the United States incorporated the refugee definition in the 1951 Refugee Convention, the US had a number of national law refugee definitions. And in amongst them was a resettlement program, which included refugees from natural catastrophes. Yeah? And in fact, there were 3 or 4 different definitions at different points in time that included that. So if you like, nothing is new under the sun, at least as far as US resettlement policy is concerned. The second broader point I was going to make actually about contemporary events is just to give everybody a reminder that next week's seminar is about the COVID-19 pandemic. And of course, COVID-19 is itself a natural hazard. Yeah, it's a biological hazard. And we'll be looking next week at the very clear ways in which that has impacted on movements internationally and within countries as well. So do tune in next week if you're interested in that kind of particular issue.
Thank you, David. You said next week. I'm assuming we are referring to the 17th of March, right? So in a month's time, we are talking about the same.
Time flies during lockdown, what can I say?
Yeah, exactly. So thank you so much, David, for also sharing that historical. I remember that from your work that you looked into these historical opportunities in disaster settings within the US law and policy. So that's very interesting to have in mind. Lucy, would you like to share a few final remarks from your side?
Thank you, Atle. Just one remark that would like to appreciate the university, Professor David and the team, as well as yourself, Professor Walter. I haven't seen him here, and yourself, Atle, and also Lina, for actually supporting IGAD to make sure that there's a protocol that actually addresses the issue of natural disaster displacement. Now, the other thing I just wanted to mention is that going forward, we may need to continue with this sharing of global practice, because one of the challenges that we have with our member states is the fact that they tend to, to act in their own capacities, trying to address displacement from national disasters. And there's a gap with sharing on global practice what would be the best models that we could also employ in the region or within countries. I think if the university and PDD can carry this information sharing platform forward, it would be very helpful, especially finally when we'll request PDD again to come on board to support us with preparation of cabinet papers in all the member states, because the cabinet papers then will help with the ratification of the protocol at member state level. So we'll be in touch still and draw on you closely to support the Secretariat and the member states on carrying this policy commitment at the regional level forward at member state level to ensure that the ratification process is well informed and that we can actually get into the national policy making process, but also practice in responding to natural disaster displacement within IGAD member states. Thank you so much once again. It was a pleasure being part of this, and the Secretariat again is very appreciative that you keep us on board. Thank you.
Thank you, Lucia, and well noted. We look forward to continue cooperation. Also would like to thank you for your director's remarks that she made at the commemoration last week. That was very well received, so very happy. I think we are 1 minute over time, so that's not outrageously bad time management. I would like to thank our speakers, particularly without underestimating the value of David and Lucy. I think Richard and Jane should receive an applause for staying with us early into their morning. It's really great to see you, and this has been a great seminar. I cannot really summarize this in a meaningful manner with a short time, but what I can maybe take as one message is that there is work for everyone here. There's really so many aspects and approaches at different levels we can support this protection agenda, if you allow me to call it that. So there's work for absolutely everyone here, and we have gotten so many good ideas on where to plug in our efforts. As David said, this is the second to last seminar on the 17th of March. We would like to invite you again and also look at some of the implication of a post-COVID-19 situation. And we will then also take a little stock of the seminar in its entirety. So we welcome you back. Thank you so much for your attention. And I wish you all good morning, good afternoon, or good evening. Thank you so much.